Sam Seder on the Majority Report. I want to welcome to the program Lisa Heinzerling, a law professor at Georgetown University. Lisa, thanks for joining us.
Thanks for having me.
Let's start with, now you've written a piece in about the sort of ongoing assault by the Supreme Court on our government's ability to govern in many respects. But let's start with this Mifepristone case because it's almost like a cousin, or at least one of the claims, sort of a cousin to this idea of the Chevron Doctrine and the idea of Congress being able to delegate to executive agencies an authority to sort of to execute the broad prescriptions in a statute, let's say. So, but let's start with the Mifepristone. What was the nature of this case?
An anti-abortion group that's made up of other anti-abortion groups for the most part wanted the FDA to undo certain FDA had relaxed the requirements for prescribing and administering Mifepristone, which is used, among other things, to induce abortions. And
my understanding is 50% of abortions in this country now are a function of a Mifepristone.
Yeah, absolutely. And the latest number I saw was actually 60%. And so they wanted to have them not relax requirements, such as having the women go to an in-person appointment with a medical professional. And so they relaxed that, and these groups challenged that relaxation. And that's the kind of judgment that an agency like the Food and Drug Administration is usually given a lot of leeway on, because the FDA, that's what they do. They're charged by Congress with ensuring the safety of drugs. They're also charged by Congress with making safe drugs available to people who need them. And so that's the kind of judgment about what actually a woman needs to do in order to take this drug safely. That's the kind of judgment usually entrusted to the FDA. And the court, the Fifth Circuit, which has become notorious recently because of very, very aggressive and legally highly questionable rulings, and in particular on questions about agencies and government responsibilities. And so they said that the government hadn't done a good enough job explaining itself, and that's what came up to the Supreme Court yesterday.
Well, I've had trouble trying to figure out exactly what their claim is. I mean, their claim was very strange. It was not just that they were claiming that it was they claiming that the drug was dangerous, or they were claiming on some level that they could be personally harmed, because one of the issues is their standing in this case, that they could be harmed as doctors in having to deal with the fallout of someone taking this drug. Now, of course, it turns out most of them are retired or dentists who presumably would not be on the list of people who would be called in the event that there was an adverse reaction to this. And we know what the adverse reactions are. I mean, it was something like 32 people out of the 6 million who took it passed away. It wasn't even necessarily a direct cause of the Mifepristone, but they had taken it within a certain period of time. But what was their claim? And is this going to end up being resolved on its merits, or is it going to be a standing issue?
Yeah, so their claim, they have to say that they've been injured or going to be injured in order to get into federal court. That's just a requirement the Supreme Court has created for these cases. And their injury was very hard to pin down even yesterday at oral argument. They say that these doctors don't want to be involved in actually performing an abortion, but more than that, they don't want to be complicit in an abortion by treating a woman who is having complications due to Mifepristone. And so that the limits of that kind of principle, the complicit principle, are very unclear. And so just to cut to the chase, this case involves so many different possibilities, conjectures, speculations, before you could conclude that anyone in front of the court has ever been injured or ever will be injured by the administration of this drug. And interestingly, that is one of the features of a lot of the cases that are questioning the authority of government today, where the Supreme Court has issued other cases that have sort of flown under the radar, some of them, where the injury is highly dubious, maybe non-existent. And they just have been very lax about that. But it appears from the oral argument yesterday that the justices thought even this was too little.
Well, it's interesting because, I mean, the scary part about it, and as we, sort of pivot to your piece, and you make the point that in one of the cases that seems to be sort of taken up by the court as an opportunity to further erode the Chevron Doctrine, which is about deferring to the expertise of agencies when they're promulgating regulations to ostensibly carry out what the law that Congress passed, that they're taking these cases and resolving them not necessarily on the material question at hand, but rather as an opportunity to further create new law, essentially, by destroying old law and overrunning precedent. And I wonder in this case, like, was there any indication? Because it seems to me like it's pretty obvious there's no claim here of damages. Like they're a third party to a, it's one thing, I guess, if maybe there are people who've taken the drug and say that it wasn't ready and the FDA didn't do their job, but they're not saying that. Was there any indication that you could tell at this point, and we won't really know until there's a ruling, but was there any indication that there was an attempt to erode aspects of abortion rights further, or empower other, I don't know whom, but was there an ideological bent to this? If they can just dismiss it out of hand as you don't have standing, it seems like something they could have probably done on the shadow docket quite easily.
Well, I think it's ideological all the way down. Just all the way down. The groups that are bringing this are sort of fronts for the conservative legal movement, in particular the anti-abortion movement. The injury they suggest is, as I say, just highly improbable, and in any normal case would not have, I think, gotten even past the first stage of litigation. The Supreme Court has decided to only decide in this case whether to overrule the Chevron case you mentioned. So it may decide the case which involves a rule about fisheries. It may decide that case without saying a word about fisheries, because it took only the most abstract and consequential piece of the case, which is, should we overrule Chevron? And so there's a way in which there's nothing about any of these cases except for the agenda of the conservative legal movement.
All right, and let's get a little more specific so people can understand what we're talking about. We're talking about Loper Bright Enterprises versus Raimondo, who is the Commerce Secretary, and this involves fishing ships that have been required by the government to have basically an inspector on board to make sure that they're following our regulations about fishing, and they're required to pay for it. And the court could have said, like, well, it's not fair to make them pay for it, but they're not addressing any of the material aspects, just the broad question: can the Commerce Department, I guess it is in this instance, can they even promulgate a rule like this, never mind whether the rule is right or wrong?
Yeah, they're just answering whether, maybe not even whether they can promulgate it, but just answering the very, again, conceptual question about whether courts should be deferring to the legal interpretations of agencies. And this is a rule, the rule at issue here, and this is, this is why I say it's a pattern with the Supreme Court to these days, is the people who are complaining about the rule have never been required to change their behavior. They've never paid a dime so far as the court pleadings reveal. The rule has been suspended for a year, and it's probably not going to go into effect unless there's an appropriations specially designed for that purpose. So it's all a quite hypothetical dispute again. And yet this is the case that they've chosen to decide this highly consequential question about how the court should approach the interpretation of a statute when an agency is charged by Congress with implementing that statute. The agency typically has subject matter expertise, and so the courts for decades have said, we're gonna, when the statute is unclear, we're gonna give the benefit of the doubt to the agency. And that's the principle that the court is thinking about undoing in Loper.
Have we ever contextualized for us, because I don't know if people fully grasp the idea that generally what the Supreme Court is there to do, and I'm old enough to remember when the conservatives on the Supreme Court said we shouldn't be an activist court. That entire sort of like buzzwords and memes and euphemism seems to have completely evaporated from the mouths of Federalist Society people since the court became stacked with basically Federalist Society members. But when we have a situation where the court is not addressing an actual thing to be adjudicated, right? Like this is, and I'm trying to really lay this out for people who aren't familiar with this stuff. It's rare for particularly the Supreme Court, which doesn't have that, infinite, there's a lot of cases that they could take. It's rare for them to address cases that don't need to be resolved. Because nobody's paying these fees, like you say, it's not going to happen. There's no one's going to be made whole or not whole after this. There's going to be no real world implications for these fisheries or for the Commerce Department. Yet they're taking this case as a mechanism in which to sort of build a body of law. How compare this court's doing of that with courts in the past? Is this has there ever been an era where this has happened as much?
Well, I think that I don't know. You'd have to go back to what's called the Lochner era, when the Supreme Court was undoing all sorts of social legislation at the federal level and at the state level, and trying to really undo at the latter part of that court's reign was trying to undo some of the New Deal programs. And here it just doesn't make any sense to say that this is a passive court or a reluctant court or a careful court. I am struck at how many different layers there are to the Supreme Court's war on government, essentially, today. And it coincides with the ascension of three Trump-appointed justices to the court. And I think we see that. They don't have to be careful. It's Justice Roberts, who I think Chief Justice Roberts says this very concisely, which is he's always saying, if it's not necessary to decide more, it's necessary not to decide more. And that's just the basic principle. Courts are supposed to decide cases in front of them. They have lots of seemingly strict rules about how to figure out what cases belong in front of them. They don't issue advisory opinions. I can't just go to the Supreme Court and say, could you tell me whether this law is constitutional? Because I don't want to bother with it if it's not. They can't do that. And so this is it's very striking to me that the relaxation of requirements for an actual controversy in front of the court is occurring at the same time of maximal aggressiveness with respect to the substance of the law. So that the court is at once, again, not really policing as strongly as it has in the past, the boundaries of disputes in courts, but then also is taking aim at Congress's power, the agency's power, the president's power, and at the end of the day, the only institution left more powerful is the court itself.
Is that surprising though, or is it just like, I mean, could you? I mean, it seems like it's a part of an agenda. Like, I mean, if you have an agenda that you're going to sort of, and we should say the Lochner era basically was reversing a lot of like what happened during Reconstruction, or at least finding ways to sort of reimpose, the as much disempowerment of freedmen that we could do in terms of voting, et cetera, and then into the New Deal era, like you say, where it's like we're going to prevent government from doing things, even whatever it is, child labor, a 40-hour work week, Social Security if they had an opportunity to, and so. I mean, what is your sense of, I know, we had 3 Trump appointees on there. They're not necessarily, I don't know, Kavanaugh has more of an agenda than, let's say, Sam Alito, but it has basically allowed Alito and Clarence Thomas in particular, it seems, to have enough power to really impose this agenda.
Yes. And if you have 6 justices, you only need 5. And so when you need 5, you're probably more careful, less aggressive than when you don't. And the justices, in particular, the newest justices, I think were put on the court because of perceptions in the White House about their anti-government leanings. That was major push then. But all this is to say a couple of things, that this doesn't mean that other justices aren't on the court, haven't been conservative. They have. The court has been very conservative for a long time. Right? It also doesn't mean that there have been that I'm saying that there have never been activist courts before. It's just, I'm struck by the kind of the speed with which they're moving, the aggressiveness, and maybe it's also fed by the fact that we have lower courts now that are extremely aggressive, as I mentioned at the outset, the Fifth Circuit. And so there gets to be this kind of conversation that I find is unproductive between the extreme lower courts and the extreme Supreme Court. And so there are a lot of things at play. Beyond the ascension of a supermajority of conservative justices, but the importance of that really can't be overstated either.
Let me just ask you, in the context of the institution of law school, broadly speaking, is there a growing sense that I don't know where I don't know your journey in this respect, but is there a growing sense that the some of the emperor has no clothes when it comes to the idea that the Supreme Court is not ideological, that these guys follow some type of like consistent mechanism of the law, and they are bound by these things, and or is there a growing awareness that they have a destination and they are sort of backfilling whatever they need to? We can come up with a new doctrine, the major questions doctrine, which is basically like, the functionally equivalent of like a get out of jail. It's like a wild card. We're gonna throw it down and we'll have it mean whatever we want it to. What is your sense of like where the institution of law in this country is in that regard?
I think it's fragile. Honestly, I think it's fragile, and I think that it's, again, a collection of a number of different forces at work. The installation of justices who should have been appointed by other people in some cases, and the financial revelations about the justices, the ties to interests with matters before the court. And this sense that any obstacle existing in law to an agenda, to a pre-existing agenda, will simply be removed. Right? It'll simply be removed. That a case like Chevron, which stood for decades and was preceded by decades and decades, maybe hundreds of years of deference, that can just be simply removed. And so there's a way in which that's quite. You asked about law schools. It's quite unsettling for law students learning about the law to think that arguments don't matter.
I guess I'm more interested in the professors. I mean, because I just wonder, like, is there? Well, I mean, look, we're 8 months away, 6 months away from an election where we may have a president who appointed 3 of these justices. Maybe they'll have an opportunity to appoint another one, even. But to have a court that seems to be fundamentally driven by ideology, and particularly with the protection that may come from having a president who's also sort of like incredibly polarizing, it seems like I don't know, that maybe people in the legal institution would have a break the glass plan.
Yeah, I'm thinking in 2 opposite directions. So let me just tell you both of them. One is, to me, I've been disappointed to some extent by the failure of judges and some academics to call out some of the methodologies of the justices that are being deployed to do such harm. And so originalism and textualism are 2 of them. So for a very recent example, Justice Breyer's now, as you may know, written a book about reading the Constitution, and he takes on originalism and textualism, which is the way that the majority of the justices approach interpretation. And yet when he was on the court, he wasn't a big critic of those methodologies. And so to some extent, I feel that both academics and sitting judges should be resisting some of these methods that, they may just be a veneer for a decision made on other grounds, but you should point out that it's a veneer. You know what I mean?
I agree. It's a little bit late for Breyer to be worrying about these things, without a doubt. Lisa Heinzerling. I don't know why your name is difficult for me to pronounce. I mean,
me neither. Yeah.
I have a lot of names that I can't pronounce. Law professor at Georgetown University. Thanks so much for your time. I really appreciate it.
Yeah, thanks.